property. Mortgage of building independently of the land. While a mortgage of a parcel of land necessarily includes the improvements thereon, in the absence of a stipulation on the improvement thereon, like a building, still a building by itself may be mortgaged apart from the land on which it has been built. Such mortgage would still be a real estate mortgage, for the building would still be considered immovable, even if dealt with separately and apart from the land. Lung Yi versus Strong Machinery, 37 Phil 644. The real estate mortgage over machineries and equipments is even in accord with the classification of such properties by the Civil Code as immovable property. Article 415. Star 2 versus Paper City Corporation of the Philippines, GR 169-11, 2013 case. Machinery is movable. What is the exception? Machinery is, as a rule, movable. However, if it was placed by the owner on his land or building to respond to his needs in industry, it is considered as immovable by destination. The machinery is a movable property if it was placed by the tenant, not by the owner. Immobilization by destination cannot be made by one who is not the owner of the land. However, if there is an agreement in the lease contract that the machinery shall be owned by the lessor after the expiration of the contract, it is considered as an immovable because the lessee becomes the agent of the lessor. Davao Sawmills Company versus Castillo, 61 Phil 709. Meralco Electric Post, is it considered immovable? While the local government code still does not provide for a specific definition of real property, sections 199 and 232 of the said code respectively gives an extensive definition of what constitutes machinery and unequivocally subjects such machinery to real property tax. The machinery subject to real property tax under the local government code may or may not be attached permanently or temporarily to the real property, and the physical facilities for production, installations, and appurtenant service facilities, those which are mobile, self-powered, or self-propelled, or are not permanently attached, must A. be actually, directly, and exclusively used to meet the needs of the particular industry, business, or activity, and 2. by their very nature and purpose, be designed for or necessary for manufacturing, mining, logging, commercial, industrial, or agricultural purposes. Article 415, paragraph 1 of the Civil Code declares as immovables or real properties land, buildings, roads, and constructions of all kinds adhered to the soil. The land, buildings, and roads are immovables by nature, which cannot be moved from place to place, whereas the constructions adhered to the soil are immovables by incorporation, which are essentially movables, but are attached to an immovable in such manner as to be an integral part thereof. Article 415, paragraph 3 of the Civil Code, referring to everything attached to an immovable in a fixed manner in such a way that it cannot be separated therefrom without breaking the material or deterioration of the object, are likewise immovables by incorporation. In contrast, the local government code considers as real property machinery which may or may not be attached permanently or temporarily to the real property, and even those which are mobile. Article 415, paragraph 5 of the Civil Code considers as immovable or real properties machinery, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or on a piece of land, and which tend directly to meet the needs of the said industry or works. The Civil Code, however, does not define machinery. When does a movable becomes immovable? The properties under Article 415, Paragraph 5 of the Civil Code are immovables by destination, or those which are essentially movables, but by the purpose of which they have been placed in an immovable partake of the nature of the latter because of the added utility derived therefrom. These properties, including machinery, become immobilized if the following requisites concur. 1. They are placed in the tenement by the owner of such tenement. 2. They are destined for use in the industry or work in the tenement. And 3. They tend to directly meet the needs of said industry or works. Manila Electric Company versus the City Assessor and City Treasurer, Lucena City, GR 166102, 2015, August 5. What is the remedy of owner if land is registered under the name of another? It may vindicate its right through an action for quieting of title, a remedy designed to remove any cloud upon, or doubt or uncertainty affecting title to real property. The action for quieting of title may be brought whenever there is a cloud on title to real property or any interest in real property by reason of any instrument, record, claim. Their Adventure Farm Corporation versus CA, GR 161122, September 24, 2012. In the action, the competent court is tasked to determine the respective rights of the plaintiff and the other claimants, not only to put things in their proper places and make the claimant who has no right to the immovable respect and not disturb the one so entitled, but also for the benefit of both, so that whoever has the right will see every cloud of doubt over the property dissipated, and he can thereafter fearlessly introduce any desired improvements, as well as use and even abuse the property. Ears of Enrique Turing versus Ears of Teodosia Bukilaga, GR 163610, September 27, 2010. Builder in good faith. Who makes the choice? The landowner can choose between appropriating the building by paying the proper indemnity or obliging the builder to pay the price of the land, unless its value is considerably more than that of the structures, in which case the builder in good faith shall pay reasonable rent. If the parties cannot come to terms after the conditions of the lease, the court must fix the terms thereof. The choice belongs to the owner of the land, a rule that accords with the principle of accession. That is, that the accessory follows the principal and not the other way around. Even as the option lies with the landowner, the grant to him, nevertheless, is preclusive. PNA versus De Jesus, 411-557. The landowner cannot refuse to exercise either option and compel instead the owner of the building to remove it from the land. Rosales et al. Versus Castlefort, GR 157044, 2005. What is the reason? The raison d'etre for the law is that where the builder, planner, or sower has acted in good faith, a conflict of rights arises between the owners, and it becomes necessary to protect the owner of the improvements without causing injustice to the owner of the land. In view of the impracticability of creating a state of forced co-ownership, the law has provided a just solution by giving the owner of the land the option to acquire the improvements after payment of the proper indemnity, or to oblige the builder or planner to pay for the land and the sower the proper rent. He cannot refuse to exercise the option because his right is older and because, by principle of accession, he is entitled to the ownership of the accessory thing. De praversis tum lau. 136 475. It's a 1985 case. What is the intention of Article 448? The primary intent of Article 448 is to avoid a state of forced co-ownership and that the parties, including the two courts below, in the main agree that Articles 448 and 546 of the Civil Code are applicable, and indemnity for the improvements may be paid although they differ as to the basis of the indemnity. The objective of Article 546 of the Civil Code is to administer justice between the parties involved. In this regard, it has been ruled in Rivera v. Roman Catholic Archbishop of Manila, 40 Phil 717, that the said provision was formulated in trying to adjust the rights of the owner and possessor in good faith of a piece of land to administer complete justice to both of them in such a way as neither one nor the other may enrich landowner of that which does not belong to him. Guided by this precept, it is therefore the current market value of the improvements which should be made at the basis of reimbursement. A contrary ruling would unjustly enrich the landowner who would otherwise be allowed to acquire a highly valued income yielding 4-unit apartment building for a measly amount. Consequently, the parties should therefore be allowed to adduce evidence on the present market value of the apartment building upon which the trial court should base its finding as to the amount of reimbursement to be paid by the landowner. What happens if the lessee is not a builder in good faith? Lessees are not builders in good faith. They came into possession of the lot by virtue of a contract of lease executed by petitioner's mother in their favor. They are then estopped to deny their landlord's title or to assert a better title, not only in themselves but also in some third person while they remain in possession of the leased premises and until they surrender possession to the landlord. Munarvis CA 5-6 Scra 787 230 Scra 372. This estoppel applies even though the lessor had no title at the time. The relation of lessor and lessee was created and may be asserted not only by the original lessor but also by those who succeeded to his title. Feliciano v. Spouses Saldivar, GR 162593, 2009. Being mere lessee, they knew that their occupation of the premises would continue only for the life of the lease. Plainly, they cannot be considered as possessors nor builders in good faith. Rocasa v. Susana Realty, 18 Scra 1172. What happens if the house straddles on another's land? The owner of the land on which anything has been built, sown, or planted in good faith shall have the right to appropriate as his own the works, sowing, or planting, after payment of the indemnity provided for in Articles 546 and 548, or to oblige the one who built or planted to pay the price of the land, and the one who sowed the proper rent. However, the builder or planner cannot be obliged to buy the land if its value is considerably more than that of the building or trees. In such case, he shall pay reasonable rent. If the owner of the land does not choose to appropriate the building or trees after proper indemnity, the parties shall agree upon the terms of the lease, and in case of disagreement, the court shall fix the terms thereof. Article 448. That the house straddled the lot of another, and that it had been built in good faith. Article 448 of the Civil Code, which spells out the rights and obligations of the owner of the land as well as the builder, is unquestionably applicable. Consequently, the land being the principal and the building the accessory, preference is given to the owner of the land to make the choice as between appropriating the building or obliging Angeles as the builder to pay the value of the land. Angeles versus Pascual, GR 157150, September 2011. How about the sale of co-ownership? The forged status of an SPA makes a real estate mortgage contract null and void, but only with respect to the share of the other co-owners, that is, respondents, whose consent thereto was not actually procured. While a co-owner, by virtue of Article 493 of the Civil Code, has the right to mortgage or even sell her undivided interest in the said properties, she could not, however, dispose of or mortgage the subject properties in their entirety without the consent of the other co-owners. Accordingly, the validity of the subject real estate mortgage and the subsequent foreclosure proceedings, therefore, conducted, should be limited only to the portion which may be allotted to it as the successors in interest in the event of partition. Rural Bank of Kabadbaran versus Milicio Yap, GR 178451, 2014. When does prescription run against co-owners? Prescription as a rule does not run against co-owners and co-heirs as long as the co-ownership is expressly or impliedly recognized. The exception is when there is repudiation, provided that the following requisites are present. 1. He must make known to the others that he is repudiating the co-ownership and claiming complete ownership of the entire property. Trinidad versus CA, GR 118904, 1998. 2. Evidence of repudiation and knowledge of others is clear and convincing. 3. There is open, continuous, peaceful, public, and adverse possession for a period of time required under the law. Santos versus Ears of Crisostomo, 41 Phil 342. Galvez et al. Versus CA, GR 157954, 2006. Partition is imprescriptible. What is the exception? The contention that partition is already barred by res judicata since the first case for partition was dismissed for failure to prosecute is not correct. The dismissal with prejudice under Rule 17, Section 3 of the Rules of Court cannot defeat the right of a co-owner to ask for partition at any time, provided that there is no actual adjudication of ownership of shares yet. The rule is so because no co-owner shall be obliged to remain in a co-ownership. Each co-owner may demand at any time the partition of the thing owned in common, and so far as his share is concerned. The law generally does not favor the retention of co-ownership as a property relation, and is interested instead in ascertaining the co-owner's specific shares so as to prevent the allocation of portions to remain perpetually in limbo. Thus, the law provides that each co-owner may demand at any time the partition of the thing owned in common. Quintos et al. Versus Nicholas, GR 210-252, June 16, 2014. Between dismissal with prejudice under Rule 17, Section 3 and the right granted to co-owners under Article 494 of the Civil Code, the latter must prevail. To construe otherwise would diminish the substantive right of a co-owner through the promulgation of procedural rules. Such a construction is not sanctioned by the principle that a substantive law cannot be amended by a procedural law. Philippine National Bank versus Asuncion, 170 Phil 356. Thus, for the rules to be consistent with statutory provisions, it was held that Article 494, New Civil Code, is an exception to the Rule 17, Section 3 of the Rules of Court, to the effect that even if the order of dismissal for failure to prosecute is silent on whether or not it is with prejudice, it shall be deemed to be without prejudice. How about dried up river? Is it an accretion? And hey, before I continue, if you're not already subscribed to me, please hit that subscribe button. It's free and you get notified with all my audios. Also, please let those ads play. It helps pay for the monthly subscription of the apps that I'm using. And if you have any feedback or suggestion, inbox me or leave me a comment. Thank you. It is erroneous to treat the dried up river bed as an accretion that became the property of the adjacent owner pursuant to Article 457 of the Civil Code. That land was definitely not an accretion. The process of drying up of a river to form dry land involved the recession of the water level from the river banks, and that the dried up land did not equate to accretion, which was the gradual and imperceptible deposition of soil on the river banks through the effects of the current. In accretion, the water level did not recede and was more or less maintained. Hence, as the riparian owners had no legal right to claim ownership of the same. The state exclusively owned the lot and may not be divested of its right of ownership. Article 502 of the Civil Code expressly declares that rivers and their natural beds are public dominion of the state. It follows that the river beds that dry up continue to belong to the state as its property of public dominion, unless there is an express law that provides that the dried up river beds should belong to some other person. Republic versus Santos III, GR 160453, November 12, 2012. Distinguish occupation from possession. Occupation and possession are distinguished as follows. 1. Occupation is a mode of acquiring ownership, while possession is not. Occupation itself and proper confers ownership, but possession does not by itself give rise to ownership. 3. Only corporeal things can be the object of occupation, whereas not only things but likewise rights can be the object of possession. 4. A parcel of land cannot be the object of occupation while the same can be the object of possession. Article 714. 5. Occupation can take place only with respect to property without an owner, while possession can refer to all kinds of property whether with or without an owner. What is the concept of tacking of possession? Under the law, possession of hereditary property is deemed transmitted to the heir without interruption and upon the moment of death of the decedent, if inheritance is accepted. In the case, it was accepted since he continued possessing the land. This is so because an heir's possession is tacked to the possession of his father. In the computation of the time necessary for prescription, the present possessor may complete the period for prescription by tacking his possession to that of his grantor or predecessor in interest. Article 1138, 533, NCC. What is the remedy of the owner of movable if unlawfully deprived? Under the law, one who has lost an immovable or has been unlawfully deprived thereof may recover it from the person in possession of the same. Article 559. The term or phrase unlawfully deprived extends to all cases where there has been no valid transmission of ownership, including a depositary or a lessee who has sold the same. Dizon versus Suntai, 47 Scra 160, or Ledesma versus CA et al., GR 86051. If there was a perfected unconditional contract of sale between the seller and the buyer, and the former voluntarily caused the transfer, title thereto was acquired, the subsequent dishonor of the check merely amounted to a failure of consideration which does not render the contract of sale void, but merely allows the prejudiced party to sue for specific performance or rescission of the contract and to prosecute the imposter for estafa under Article 315 RPC. Ledesma versus CA GR 86051. Extinguishment of Usufruct. Usufruct may be deemed terminated or extinguished by the occurrence of the resolutory conditions provided in the title. Creating the usufruct. The deterioration of the relations of the kins to almost irretrievable level is a good reason for the termination of the usufruct. This is aside from the provisions of Article 603 NCC. Moralidad versus Spouses Pernes, GR 152809. By express provision of laws, as usufructuary, he does not have the right to reimbursement for the improvements he may have introduced on the property. Under the law, the usufructuary may make on the property held in usufruct such useful improvements for mere pleasure as he may deem proper, provided he does not alter its form or substance. But he shall have no right to be indemnified. He may, however, remove such improvements should it be possible to do so without damage to the property. Article 579. The usufructuary may set off the improvements he may have made on the property against any damage to the same. Article 580. If the rule on reimbursement or indemnity were otherwise, then the usufructuary might improve the owner out of his property. He may, however, remove or destroy the improvements they may have introduced thereon without damaging the property. The next topic would be on easement. So go ahead and hit that subscribe button and be notified when I upload the next audio. I totally, wholeheartedly appreciate it.